And we're coming to you live from our set here at First Liberty Live. An appeals court is about to hear the case of the fire chief who was fired for attending a leadership conference that happened to be held at a church. You'll get to hear the arguments live as it happens. Hi, I'm Stuart Shepard, and this is a special edition of First Liberty Live. In just a few minutes, the 9th U.S. Circuit Court of Appeals will hear the case of a fire chief who, as I just mentioned, was fired for attending a leadership conference because they didn't like where it was being held, and we're going to talk about that. My colleague and friend Jeff Mateer is our Executive Vice President and Chief Legal Officer here at First Liberty Institute. Hey, Jeff.
Hey, Stuart.
Thanks for joining us today. We're going to set the scene for you and explain what you're about to see as we share with you. It's kind of an online Zoom call as far as the court session. It's 2023. It's how we do things since 2020. But we're going to explain what you're going to see, who's going to be talking, so that as you watch it, you'll have a sense of the environment that all this is happening in, so you get the bigger picture of it. So Jeff, set the scene for us. Where is the court? Who are we going to be hearing from? Who are we going to be seeing?
Well, it's the 9th Circuit, which is based in San Francisco. So the rest of the country has kind of moved on from COVID. Some parts of our country haven't.
True.
And so in an abundance of caution, this is an online argument. And so what you will see is at the top of the screen, you'll see 3 judges. Those are the 3 judges who are hearing this case. Normally, I would have said those are the 3 9th Circuit judges. But in this case, we have 2 9th Circuit judges, and they've appointed specially to hear this case another judge who's a district court judge from New York. So that's what viewers will see if you're watching.
Is that a common thing to bring in?
It doesn't happen in every case, but it does happen. The workloads of the courts are such now that they don't have enough judges to hear all the arguments, and so they will occasionally ask a district court judge to sit by what's called by designation. In this case, it's a judge from New York, Judge Corman, who had been a judge in New York City. And he's now what's called senior status, so he's sort of semi-retired.
Yeah. And
part of his semi-retirement is he gets to hear a case from the 9th Circuit today.
And the other 2?
The other 2 are sitting 9th Circuit judges. On the left is Judge Akita, and she was actually appointed by President George W. Bush.
Okay.
And then in the center is Judge Gould, who is a Clinton appointee back in 1999. So you've got two Republican appointed judges and 1 Democrat appointed judge.
Now, people who follow the courts even lightly, the 9th Circuit has a reputation for being left-leaning. So we'll see how they do today. But I want to give people a move away from that and just talk about the fact that those 3 judges are selected randomly from a larger group that serves all of these courtrooms on the West Coast, right?
Yeah, I believe that there are 27 judges who sit on the 9th Circuit, and so you get a random draw, and because they're short on this one, we get 2 9th Circuit judges, and then we get a district court judge who's appointed by designation, and quite frankly, as you mentioned, I mean, generally the 9th Circuit are the 27 judges lean to the left. This is a pretty good draw for our case. Judge Akita she's superb, and actually one of our colleagues here at First Liberty clerked for her when he was in law school, and so we think very, very highly of her. Judge Gould is a Clinton appointee, and you can expect, Clinton appointee could be a little hostile, but they'll be respectful of our lawyer. Yeah. We don't know much about this Reagan appointee judge, just that he's been a judge a long time, since 1985. Yeah.
This is all about Ron Hittle. We've got his picture here between us. Give us a summary of that case. What happened and how did it end up in court?
So I mean, Ron Hittle is one of those guys. As you're a kid, you aspire to be, right? We all wanted to be firemen. Well, that's what Ron wanted to be, and he served for 24 years and ultimately rising to be fire chief in the city of Stockton, California. And, just a great guy, great guy, and in every sense of the word, loyal and service-oriented. Well, his supervisor at the city suggested that he and his leadership team attend some leadership training.
A common thing if you're a manager of people.
Yeah, you want to, you want to be, iron sharpens iron. You want the best to train you. And so what Ron sought out was, well, I'm going to seek out a training program. And what he learned of one is one called the Global Leadership Summit. Held by Willow Creek Church.
Out of Chicago.
And what they did, and I've actually attended. I've attended more than once.
Yeah.
It is premier leadership training. It's not Christian leadership training.
When I went to one, you may have had the same experience. It's not a bunch of Christian speakers who have a book that just came out. Yeah. The head of Starbucks was scheduled for the one I was at. A guy named Seth Godin, who's a top-level marketing guru, showed up at it. I mean, these are people out in the secular world that they bring in to share their ideas. I mean,
and I'm sure our viewers are familiar. The book Good to Great. I mean, it's sort of in the the Harvard Business Review's #1 business book in the last 50 years by the author Jim Collins, who's a practicing Buddhist. That was, one of the keynoters at this. In addition, Daniel Pink, who probably some of our viewers are familiar with, another leadership guru. Tony Dungy, I think we all know Tony Dungy, the Super Bowl winning coach. Yeah. T.D. Jakes, who is a pastor, but also a huge proponent of leadership. Jack Welch, the former head of GE. These are the type of people who teach at this. Again, it's not a Christian leadership conference. It's a leadership conference. And that's what Chief Hittle took his folks to, and get this, at his own expense. So the city wasn't out a dime, but at his own expense. And simply because the leadership conference was held at a church, the powers to be at the city of Stockton said that it was impermissible.
Now, I'm not an attorney, okay? But to me...
You're almost. I mean, you've learned so much the last few years. I think you could sit for the bar exam.
I know more Latin now than I knew when I was in high school taking it in a class, but that's another story. It occurs to me, I know churches that meet in schools on the weekend, okay? But it's not a school when they're meeting there, it's a church, but it's a school building. Well, if you have a leadership conference that happens to be held in a church building, it's just a building. It's not a church, right? It's just a leadership conference in a building.
It's just a building. And what's the key in this case is that the city is specifically saying, you attended a religious event, and therefore we're firing you. And the fact that it's held in a church doesn't necessarily make it a religious event. Now, it could have been a religious event had it been Sunday morning worship or Bible study, but that's not what this is. The church opened up its facility to have a leadership event. The chief went, almost said coach, because I'm so used to Coach Kennedy. The chief went to that, not because it was at a church, but because it was where this premier leadership summit was taking place. And the city sees it, and they hear the word church, and they say, well, you can't go to that because it's religious, which then triggers his protections, because under federal law, under Title VII, one of the classifications, you can't discriminate. You can't discriminate based on race. You can't discriminate based on sex.
And that's civil rights law, right?
It's civil rights law passed in 1964. Applies to all employers with more than 15 employees, which clearly the city of Stockton has. And they admit in their termination, we fired you because you went to this religious event.
Worth pointing out, he chose to go. The people who went with him
chose to come.
Chose to go. They're all adults.
No one was forced.
He paid for it.
Yep.
I cannot figure out for the life of me, as a non-attorney, what the problem is here. So let's talk about the arguments that are going to be made today. What's the key argument that our side will be making? Who's going to be making it as well? And what are we going to hear from the other side?
Well, one of our network attorneys from Baker Botts, Elizabeth Butler, will be arguing for us. She'll be sitting beside her. Viewers might find interesting. I don't know if it'll be on camera or not. Usually the person next to you isn't, but it'll be Aaron Street.
Yeah.
People should be familiar with him.
We just had him on First Liberty Live a week ago.
Yeah, and he's going to be arguing the Groff case, which will be at the Supreme Court in just a few weeks.
Yeah.
So Elizabeth works with Aaron. Elizabeth will be arguing, and what she'll argue is basically what I just said. And sort of the common sense argument is, You fired him because he went to a religious event. You admitted you fired him for going to a religious event. That's a textbook violation of Title VII, which says you cannot discriminate against someone because of their religious beliefs or practices.
Among other things.
Among other things.
Yeah.
And so it'll be a pretty simple argument. Now, with the other side, what the city's lawyers is going to argue is, well, no, he was fired for other reasons. The problem is
they admitted it.
They admitted it.
Yeah.
And it doesn't need to be the only reason. If you fire someone and it's part of the reasoning, then you violate the law.
And my understanding is in employment cases, it's common that someone will get fired for a reason, but then if it ends up in court, suddenly there are all kinds of reasons that show up at the last minute, but the court is taught to ignore that, right?
Right, and you focus in on the reason. And again, the words speak louder, the words at the time speak louder than arguments today. The words at the time is, we fired you for going to this religious event, and it's not just words, it's words written down.
Yeah, I want to mention, this is just the coolness of the day that we're having here at First Liberty Institute. You'll see that they're in a room that may look a little familiar to you. They're actually in a studio just down the hall from us
Yeah, I
here.
mean, we could almost throw and hit them with. If I had a baseball, I could throw it. Although I have to throw it through some offices.
25 feet that way and right, and they're in our uplink studio.
I had a pretty good curveball. Although I think that would be a screwball.
That would be all the way around. Yeah, you'd probably get
but yeah, they're very close.
Tossed out of the game.
Which is, that we're very privileged. And because of our supporters, that we can have a facility where we can have an oral argument. I mean, or we can, in some cases, we can be on Fox News and be right here in our office.
It gives us plenty of opportunities to take the stories about our cases to people out there, whether it's on Fox News. We've done CNN from in there. We've done local stations all over the country in there. It's really helpful and actually gets our message out to a lot more people because it's so convenient for us to just step in there and send it out.
And it lets us do more and do it more often.
This goes really quick. When you watch a TV argument, I mean, they really cut it down, but in real life, this is still really quick. Tell us what each side will get to do.
Yeah, and this is shorter than a lot. I mean, when people watch the Supreme Court argument, we'll have more time, but this is 15 minutes per side. What I anticipate is what Elizabeth will go first, because we actually, believe it or not, as simple as this case is, we lost at the district court on what's called a motion for summary judgment, which is we didn't have a trial, just based on the papers, the judge ruled against us. And so we go first. Elizabeth will reserve some of her time at the end. So she'll probably go 10 to 12 minutes and then reserve the remainder of her time. Then the city's lawyer will go for 15 minutes. And then whatever time Elizabeth has left, she will go. Now, that's how it's gone.
Supposed to go.
But sometimes, as we know, in the Supreme Court especially, judges control it, so they can ask questions as long as they would like. But usually it'll go 15 plus 15, so 30 minutes.
And part of what we're doing here today, the court is hearing multiple cases. So we've got our team watching the screen just out of behind the camera view here. There's another case that's being heard right now, and they're arguing that as we go. So we're waiting for them to wrap that one up. They started about 5 minutes late on that one as far as the argument. So if they go the full half hour, that would put us up at, 12:35 Central.
Yeah, probably 5 minutes.
So that's the timeline that we're on. That's if they go 15 minutes each side. They may go a little longer. So we will pick it up as soon as they switch out the attorneys and are ready to hear our case when it's there at the Ninth Circuit in San Francisco. They've already read a stack of legal briefs before they get to the courtroom. There's a lot that goes into a day like this, and that's why it's only 15 minutes per side. They've already pretty much thought about this a lot.
Yeah, most people who are experts in this area of the law, in appellate arguments, say that the judges probably have already decided where they are. They're probably 90% sure where they are.
Yeah.
They have, first off, they themselves may have some questions. And the other thing that they might be doing is, let's say you have one judge who's strongly for us. He or she may be trying to convince one of her colleagues to join her, if it's she.
Yeah.
And some of the questions could be directed towards trying to have that colleague join. Now, we especially see that at the Supreme Court.
Right.
When there's sort of, the person arguing is sort of almost just there, but it's really the justices talking to each other.
Yeah.
That can't happen at the appellate court. I mean, here it's only 3 judges, not 9. But you can have one judge asking a question, which really the judge is asking that question to make a point to one of her colleagues.
Did they talk about the case before this day?
No, they have not talked about the case beforehand. So what has happened is the briefs have been filed. We've filed a brief as appellant, the person appealing the decision.
Yeah.
Then the city has responded as an appellate. Then we filed what's called a reply brief. So you've got those 3 briefs. And then each of the judges has law clerks who've probably done a memo outlining the key arguments for the judges, perhaps suggesting some questions. And so all that's going on before they actually sit down and argue today.
And we're not going to get a decision today. I want to set expectations
No.
here. It's usually months before.
No,
we
and sometimes you can read some tea leaves into it based upon the questions, but you got to be careful about that because judges don't always show everything that they're thinking.
And sometimes they're trying to ferret out a particular point in the law for their colleague down the bench.
Yeah, I mean, one of the hardest things, having done I've never argued the Supreme Court, but I've argued at the appellate courts is, when you get a friendly question, you've got to think where are they going with this questions. A lot of times it's easier to have hostile questions because you're prepared to respond to that. So as Elizabeth argues today, the viewer can be thinking, well, is that a friendly question or is that an unfavorable question? Is it hostile? And sort of aware, because that's what we're doing. I mean, we'll watch and try to see where the judges, what they're asking, and then try to determine whether, is that indicating they're for us or with us. But you're right. I mean, we would expect a decision. It's months away.
Give us a sense of the preparation that goes into this as far as how many people are working around the person who'll be speaking for our side and how many hours of work going to prepping for this argument.
Yeah, I mean, it's hours and hours. And so you've got the team at Baker Botts, our network attorneys who are supporting Elizabeth. So
who are top-notch attorneys.
I mean, the best
good as it
attorneys
gets.
is the best attorneys in the country. It's a premier law firm. And if you owned a business, who is threatened, you would hire
at a very high rate.
Yes, at a very high rate. I mean, hundreds of dollars an hour to hire the best because they deserve the best. And of course, Chief deserves the best, and these guys do it for free.
For us.
Our Latin word that you know. What's the Latin word that we know?
I don't know.
Pro bono.
Pro bono,
You know
yes.
pro bono.
Oh, I do know that
You
one.
know
Yeah.
pro
I always think
bono.
it's Sonny Bono, but whatever.
No, pro bono, which means for free.
Yeah.
That they're handling it, and so the team for Baker Botts is working, and then the team here at First Liberty supporting them, and so part of that is the briefing that we talked about, preparing those written briefs. And I should also mention on this case is our good friend that I know you had on First Liberty Live recently, Alan Reinhardt,
Yeah.
is our co-counsel on this case as well, and who brought it to us to help on appeal. So we got to, obviously give a good shout out to Alan for doing that. So Alan's been working on this through the trial court. He has hundreds and hundreds of hours. And then the First Liberty team has come on board and also put hundreds of hours into it. First in briefing, and then what we do is something called moots. You know that word?
Yeah, it's practice.
It's
set them
practice.
up and grill them.
Exactly, and Elizabeth has done that. Kelly Shackelford, our fearless leader, participated in the moots, getting Elizabeth ready, as did David Hacker. I think you're going to have it after
And
the
to explain
argument.
that, basically the attorney stands before 3 people pretending to be the
We
judges.
pretend to be yes. So what we do is get the lawyer ready by pretending be the judges, and we always want the practice
To be harder
than the game.
Yeah.
And anybody who's played sports can understand the more you put into practice, the better you have in game results. And if you have a harder practice than a game, then things are well. And I know Kelly and David Hacker put Elizabeth through the ringer. And so hopefully Elizabeth will be able to say at the end that moot with Kelly was harder than the argument at the Ninth Circuit.
You mentioned Alan Reinach. We just had him on with Randy Wanger. He's with the law group that's affiliated with the Pennsylvania Family Institute that we've long had an association with,
Yes.
organizationally over many years. They were just on a week ago talking about the case we'll have at the Supreme Court next month. So if you want to watch that, we invite you to tune in for that. I also should mention we had Ron Hittle on as a guest. Peyton interviewed him just a few weeks ago. So if you look on firstlibertylive.com, you can hear his story from his perspective, what he lived through when he went through that, and get an idea of what it was. Yeah. We have a lot of good guests on here over this length of time.
No, very, very much.
Yeah. Let's talk about, is this a case that might go to the Supreme Court? People are probably wondering that, so I'm going to pose the question. I know we can't know, but...
You know, it's possible. It's possible. Certainly if the Ninth Circuit gets it wrong, we will seek review.
Okay.
And it is a pretty outrageous case, so it does reach that. But as you know, the Supreme Court only takes, what was it, 67 or something last year? It's in the high 60s.
Out of
8,000.
Yeah.
And so it's very rare to get, which then makes, last year with us having 2 Supreme Court cases,
it's God's favor.
It's just incredible. It's just incredible. And then this year to have a Supreme Court case following 2, to next year get another one. We've got the Navy SEALs case, which, that's always a possibility.
Yeah.
This case is a possibility, but it's so hard to predict, whether a case is going to be a Supreme Court case. One way that it wouldn't be a Supreme Court case is if the Ninth Circuit gets it right and we win at the Ninth Circuit, because then it becomes very, very less likely.
Because they would likely not appeal on that.
Well, or if they did, then the Supreme Court wouldn't be interested in it.
Okay.
Usually the Supreme Court doesn't. A case in favor of religious liberty, it would be very unusual for the Supreme Court to take and reverse.
With the idea being that if the decision below is one that the Supreme Court likes, if the one they would affirm, well, they're not going to pick it up and say, yeah, that really was right.
If you only do 65 cases or 70 cases a year, why would you take a case that you're saying the court got it right?
Yeah.
Now, the good is the Ninth Circuit rarely gets it right, but this is a good panel. So, hopefully this panel will get it right.
We're in the window of time when they might be starting any second here, but I just want to give people a sense of the week that we're having. It is an incredibly busy week at First Liberty Institute. Give us a sense of some of the other cases that we're working on as a team here.
Right, one of my colleagues may throw something at me, and they're telling us 2 minutes. So I'm just very, very quickly. So we will be filing this week 2 really important cases. One following up on one of our Supreme Court victories last year, and another one being a case. And I've got a lawyer who's telling me like this, Stuart. So I don't want to break things to our viewers.
But keep an eye. We'll be letting you know through our channels. A very
important case, which is really one of the first in the nation, not one of. In one respect, it is the first in the nation to help on the pro-life issue. So we're very, very excited about actually both of those cases. One being representing Christian schools, the other being pro-life.
Yeah.
And I think I can say that no one has thrown anything at me yet.
You are the boss of most of the people that are wanting to throw something at you.
I am their boss, but
But on top of that, there's even more.
Just give us a sense of number. We're filing a comment with the Department of Education opposing the Biden administration repealing a very, very important rule that impacts college student organizations.
Yeah.
We've got mediation in the Chabad of the Beaches case. I know you've talked about that case before, which is an important case protecting a Jewish synagogue in New York. Just one of 600 legal matters that we're working on. So, and then with our lawyers traveling everywhere, Mike Berry's in D.C. and doing training. Our team's working on Capitol Hill today. We've got the Navy SEALs case, is continuing that we mediated last week, and we're trying to work on that case.
And we were just at the Fifth Circuit with that one not that many weeks ago.
Nope, we were at the Fifth Circuit on that. The team's getting ready for the Groff case, as we talked about moot, so they're getting this. The team is getting ready for the argument on that case. There's a lot going on.
It's a fun time to be here, and I'm very proud of your team for the work that you do. Well, I know that the attorneys put in more hours than I think most people realize. I was talking with a couple of them who were up reading through briefs until 2, 3 o'clock in the morning, prepping for one of the cases.
Yeah, there were a couple of people who did. We always tell we don't like to see all-nighters all the time, but, sometimes the work requires it.
Yeah, and they work hard, and we're very proud of them and the work that they do. All your team is phenomenal. So it looks like they're about to switch over with the attorneys there at the Ninth Circuit. Jeff Mateer, thank you so much for sharing with us today. Now we're going to let you listen in to the Ninth U.S. Circuit Court of Appeals. Again, it's kind of like a Zoom call as they hear the case of Ron Hittle. Camera one? Okay. As you could probably tell, there are some technical difficulties. It appears to be on the court's end. We had the live feed called up. It was supposed to roll right into the next one, and it appears they have stopped the feed. So we've got our team working on that, and we'll pick it up as soon as they once again feed it out, but we will check and see what happens. Our expectation was, and what the court showed was, that it would roll right into this one. So we will keep working on it and let you know. If we just can't get it, by the way, we will see if we can find the feed after the fact and put that on firstlibertylive.com so you can watch it. But we're still hopeful that the tech wizards in San Francisco will get this figured out and get it streaming out again. Any luck over there? We know that the connection was good because we were watching the case that came right before this one, so everything was happening, and then they were switching them out, and then somebody pushed the wrong button in San Francisco. Here's what we'll do. We'll keep our live feed going. I'm going to duck out of here for a second, and we will keep working on bringing it up. Jared, if you want to bring up the full screen there, just so we have something up, and we'll be back in just a minute if we can figure out what to do to get the feed to show up.
they and they went at city expense.
Yes, Your Honor, a few responses to that. So there's no city policy that requires Chief Hittle to check with Montez before he goes to leadership training, but Chief Hittle testified that Montez never specified that he needed to obtain public sector leadership training or fire department specific leadership training. So there is a factual dispute on that issue, but I would submit that even that factual dispute is not material because there is evidence in the record that the leadership training did meet these specifications that Montez claims that she gave Chief Hittle. So the Leadership Summit included a specific speaker, Daniel Pink, who is also a speaker at the International City County Managers Association, which is one of the entities that Montez claims she told Chief Hittle would have been appropriate leadership training. But I would also say, moreover, the city did not ever look into the type of leadership training that the summit provided. So for it to now say that it terminated Chief Hittle because he didn't attend the specific kind of leadership training that they wanted to attend, that just has no support in the record at all.
What about the others that he took and approved payment for their work as a work day in effect and at city expense?
Yes, others did accompany Chief Hittle. So the others who came all held some type of management position in the fire department. So Chief Hittle brought them along so they could also learn from this leadership event.
So that was his decision. No one told him.
That was his decision, but as fire chief, he didn't have to obtain approval from anybody else to bring the other managers. And I don't believe the city has ever raised the issue that Chief Hittle wasn't allowed to obtain leadership training for other managers within the fire department. The city's issue with the training has always been the religious perspective. So the city's documents, which all refer to the religious nature of the leadership event, along with discriminatory comments made by the city's decision makers, provide conclusive evidence that religious discrimination was at least a motivating factor in Chief Hittle's termination. But at minimum,
what if they had said, in effect, you know, he went to a baseball game on city time and city expense, and he took three others with him?
Right. Well, that would not be.
Would that have been a ground to discipline him and take action against him?
I would say yes. I don't see what benefit the city could have obtained from Chief Hittle taking his other managers to a baseball game, but that doesn't implicate Title VII.
No, I know it doesn't implicate Title VII, but you know, the description of it as a religious event, as religious, it doesn't strike me as being the critical factor. What they were assuming it was religious. It doesn't seem to me to be the critical concern of the city was that he went to a program which the city did not think met its requirement when they told him to go, and that was the basis, and that he took other people with him at his expense.
Your Honor, I would push back on that characterization. I think if you look into the Largent report, so the city's investigation report, which City Manager Dice said he fired Chief Hittle based on the findings of the Largent report. And the only thing that the Largent report looks into with respect to the Global Leadership Summit is whether or not the summit was religious. And that is reflective of the city's religious discrimination. So that is pretty conclusive proof, in my opinion, that the only thing that the city cared about was the religious character of the summit. In addition to these documents, the city decision makers also made discriminatory comments against Chief Hittle. So Deputy City Manager Montez accused Chief Hittle of being part of a Christian coalition. This is something she said in a very pejorative tone, and she said it in connection with him obtaining leadership training. It was immediately after that the city had discovered that he had obtained leadership training that had this religious perspective. And
opposing counsel argues that Montez got this term from an anonymous letter. Does that make a difference?
No, Your Honor, it doesn't, because even if some other person was the origin of the Christian coalition term, Montez adopted this discriminatory term and she used it against Chief Hittle. So she can't shield herself from her own discriminatory comment by claiming that the comment came from somebody else. Additionally, both Montez and Dice used the term church clique in connection with the leadership training and Chief Hittle's position with the other Christians in the department. And this is also reflective of their animus. Clique is a term that is never used in a positive way. And if the panel has any kind of trouble thinking about this, I ask you to substitute in another protected characteristic. So say a Black employee was accused of being part of a Black clique and attending Black leadership training and was terminated for that. That is pretty obvious discrimination. And I submit that this is the exact same case.
Could I ask one particular question? They gave him an opportunity to provide an explanation, which he attended, I believe, with his attorney. And he didn't provide. They basically, he refused to provide any kind of an explanation. And he said this was a denial of due process, which is curious since he was an at-will employee, but they were giving him an opportunity to answer. And he didn't.
So Chief Hittle offered explanations to Inspector Largent throughout the investigation, but I believe what you're referring to is the hearing, basically once the city had already made the termination decision. And Chief Hittle didn't have the opportunity to call any witnesses or provide any kind of evidence at that hearing. So his counsel at the time made the decision not to argue further with the city at that particular hearing. But Chief Hittle certainly all throughout the investigation process did, provide numerous explanations for why he chose the Global Leadership Summit as the leadership event and the benefits that event provided. If the panel doesn't have any further questions, I will reserve the remainder of my time for rebuttal.
Okay. I have none. I don't hear any other questions, so I think you can pause and prepare for your rebuttal. Mr. Wilson.
Thank you, Your Honor. Spencer Wilson on behalf of the appellee, City of Stockton. I do want to address a few of the points that Ms. Butler made, but first I would like to focus on the real reason that the city terminated Hittle's at-will employment, and that is that he engaged in rampant mismanagement of the fire department, marked by improper favoritism and failure to maintain order and discipline. This drew criticism from at least 2 city managers, the city council, members of the fire department, concerned citizens, and members of the media. And this was documented in an exhaustive investigative report. The report and exhibits span nearly 2,000 pages. Hittle concedes or fails to meaningfully dispute most of the material facts related to his misconduct. He concedes that he co-owned a vacation home with 3 subordinates, including the union president, and he never formally disclosed this to the city. This resulted in actual and perceived conflicts of interest. For example, as Hittle conceded, one of his co-owners, Dwayne, engaged in conduct constituting time card fraud, but Hittle defended
here because notwithstanding the evidence of other problems with Mr. Hittle, our case law and the statute itself says we only have to consider whether religion was a motivating factor. And so when we look at the larger report, there seems to be a significant focus on the characteristics of a large focus of the report. So what's the basis for saying that's not a motivating factor?
So I think it's fair to say that one of the many examples of his favoritism and his mismanagement of the department was his attendance at the religious leadership conference. But that was in a long line of mismanagement and a long line of favoritism. And I believe that Judge Corman was absolutely correct that the religious nature of it wasn't the reason of the concern. And I think that the reason that the investigator questioned him about the religious nature of the event is because Hittle tried to downplay it. He said, I wasn't going for any sort of religious reason. I was going because my supervisor, Lori Montez, directed me to attend leadership training. And so she was trying to figure out, okay, what was the purpose of this? Were you going to get leadership training, or were you trying to go and engage in a religious practice? And, that was the reason why she had the inquiry about the religious aspects.
So was the reason that the attending the conference, that the thrust of the larger report and the comments made seemed to be the reason that this conference was inappropriate and shouldn't have attended it was because of the religious characteristics. Do you disagree?
Well, first of all, I'm sorry, you cut out there for a moment, Judge Ikuda.
I said, if you disagree, how do we say that they weren't focused on a protected characteristic?
So what they were concerned about was Hittle disregarding his supervisor's direction to get leadership training specific to fire departments or public sector management. And I would like to point out, contrary to appellant's assertion, that is not an argument that only appears in Montez's declaration. She also, both she and Hittle corroborated that in their deposition testimony. At deposition, Montez reported directing Hittle to obtain public sector leadership training and testified to frequently speaking with Hittle about the types of training he should obtain. She provided him examples, several examples, and he then went to a training completely out of character from those examples.
Was there something wrong with the training other than its religious nature? Because there's nothing in the larger report saying it wasn't for fire chiefs. It seemed like the main thing that was wrong with the training was that it had a religious theme, or that it was at a church. There were statements about that.
Well, she specifically asked him what benefit did it provide the city. And even at the conclusion of her interview, she said, I'm going to give you another chance. Please provide me in writing documentation of what specific training you got that benefits the city. And
so he did explain why these speakers were so excellent about training, et cetera. So what was wrong with that other than the religious characteristic?
It wasn't the religious characteristic of it. It wasn't that it wasn't public sector management or fire specific. And let me explain why that's significant here. Hittle had a long history of mismanaging his department. He didn't understand how things work. As we pointed out, he tried to defend his subordinates' time card fraud because he thought that it benefited the city, and he was wrong. And there's all sorts of public sector management and fire department specific trainings out there that talk about things specific to a fire department. How do you operate a 7K work period? How does 4850 workers' compensation leave? How do you conduct a workplace investigation under the Firefighters Procedural Bill of Rights Act?
So why didn't the Largent report say that? I mean, the Largent, it just was odd to me that the Largent report didn't say there are many types of trainings that are available for fire chiefs or upper management, and he didn't choose that. Instead, the Largent report was focused on whether the conference was religious or not. Why didn't the report focus on what you're saying now, or did I miss that?
So I really can't speak to why Ms. Largent didn't focus on that, but I will just point out that Ms. Largent, she was a third-party investigator. She reached her conclusions, and then the city based their decision on what to do with Mr. Hittle's employment based on the findings of her. So I don't know why she didn't include certain things.
About the remarks that opposing counsel raises about Christian Coalition and Church Clique. What do we do with those?
So both Mr. Hittle and Ms. Montez agree that the term Christian Coalition did not originate from Ms. Montez. It came from an outside dispute from a third party, and the concern was that Hittle was providing favoritism to certain people in the department. And in that particular instance, it was people of his same faith. And there's a long line of complaints going back to 2008 about Hittle engaging in favoritism on a number of factors: union membership, co-ownership of his home. And as Montez understood that complaint, it was a complaint about improper favoritism. And so she needed to ask him about that, because you can't favor people based on a protected category. And she understood the complaint to be that Hittle was a member of a clique, an exclusive group, and he was providing preferential treatment to the members of the clique. And you can't do that. We cite to several cases in our brief where such conduct actually violates Title VII. So it was not only appropriate for Montez to question him about these accusations of favoritism, but she had to do that. That was the responsible thing for her to do. So, Your Honors, one other point that they raised regarding the Skelly meeting. They keep saying that Hittle wasn't given an opportunity to present his case, wasn't able to call witnesses. He had no right to, even if he wasn't an at-will employee. There's no reason for doing that. And it's a very good observation of Judge Corman that he had an opportunity to raise concerns at this hearing, and nothing was raised. There were no accusations regarding religious discrimination. The Skelly hearing, the purpose of that is for someone to say, hey, you got something wrong here. This is what you need to understand. And he didn't do that. So, based on the long history of misconduct, which we've outlined in our brief, his co-ownership of his vacation home, his preferential treatment of members of his vacation home, the fact that he improperly pressured an employee to take down a political sign from his own personal lawn because it supported a position that wasn't backed by the union. The fact that Under his watch, firefighters engaged in campaign activity antithetical to city interests while driving a fire truck resembling City of Stockton fire trucks and wearing uniforms resembling official city uniforms. The list goes on. I know we cover all these in our brief, so I'm not going to go over them all again. But his attendance at this event was in a long line of him exercising poor judgment, using city funds in ways that were criticized by the public, and providing favoritism to employees on reasons other than merit. And that just simply isn't appropriate. And given the voluminous record of non-discriminatory reasons for disciplining him, there's simply no way a reasonable jury could find pretext from these facts. And we believe the district court's decision should be upheld. But I'm happy to answer any other questions.
Well, I have no question, but Judge Corman, Judge Ikuda.
Right, I don't.
Looks like you've completed your argument. No further questions. Thank you, Mr. Wilson. Ms. Butler, you have some rebuttal time.
Thank you, Your Honor. I'd like to briefly begin with the idea of pretext. So I think Judge Ikuda was exactly correct that Chief Hittle does not need to disprove all of the city's various other reasons to establish pretext on either a motivating factor or a but-for theory of causation. And I would point the court to the Supreme Court's decision in Bostock if there is any doubt on that point. Bostock has explicitly said that even under but-for causation, other reasons do not need to be disproved. And specifically—
Can I ask you one particular question to go back to this leadership event? The Largent report says that on October 5th and 6th, you used city time and resources to attend a religious leadership event.
Yeah.
That is his determination that it was a religious leadership event. Is that some sort of a neutral finding? And if that's true, is that the end of it? In other words, he is telling the city and he is characterizing it as a religious leadership event.
By he, do you mean the investigator?
Pardon me?
So who is the he, the investigator?
Largent.
Okay, yes. So Largent viewed the event as a religious leadership event, but that's not a neutral finding. The important fact is that the religion was the only aspect of the training that Largent focused on. So the religious aspect shouldn't make the leadership training per se inappropriate. And in fact, her determination that it did violates Title VII. And I think it's important to look.
Is it factually inaccurate?
It's not factually inaccurate to characterize the leadership training as including a religious perspective. If she's trying to characterize the event as a religious leadership event because she means it only provides training for the clergy, that would be inaccurate. It's somewhat of an unclear term, but it's clear that the religious nature of the leadership event was the problem. And so I just like to maybe back up a little bit and just say this decision was motivated by Chief Hittle's religious beliefs. The city knew that Chief Hittle was a Christian. They told him that he should not be part of a Christian coalition.
But was it the cities, or did they accept Largent's finding?
Well, so
they hired, after all, they did go out and hire a third party to
the city
investigation, yes. And he made this finding.
Yes, the city accepted Largent's findings, but I will say the city was the one who brought up the religious nature of the leadership event first. So the city issued Chief Hittle the notice of investigation, and the notice of investigation specifically investigates Chief Hittle for attending a religious leadership event on city time. So Largent did not originate this issue with the religious event. That was the city, and the city told Largent to investigate him for that reason. The city accepted Largent's findings, and then in the removal notice, which is by the city says that Chief Hittle was fired for attending a religious event on city time. And I would also say in response to the allegation that, well, this is all based on favoritism, the removal notice has two different causes for removal that are related to the religious leadership event. And the first is solely Chief Hittle's attendance at the religious leadership event. That has nothing to do with favoritism. Finally,
I have one more question. It sort of picks up on questions that Judge Kuda asked. Suppose there were 6 grounds. I'm just picking that number out of the air. I didn't do an actual count that would provide a neutral basis for his termination. Does the city lose automatically, or does it simply shift the burden to the city to show that they would have done the same thing anyway, even if this religious aspect was out of the case?
Judge Gould, I see my time has expired. May I answer the question?
It's up to Judge Gould.
Yes, please do.
Okay, so on these facts, that would be the case. So it doesn't, the other reasons for Chief Hittle's termination aren't relevant. They can't discount the improper religious motivation. So that won't necessarily be true in every case, but because here Chief Hittle has proven his case with affirmative evidence of discrimination using the city's own documents and the city's own comments, the city cannot avoid the city cannot get summary judgment based on those factors.
Well, I'm not thinking about summary judgment right now. Suppose the city could prove, let's say at a trial, that they would have done this anyway. And there are some pretty peculiar things that your client was found to have done, and that would, in my view, constitute grounds to terminate him. But as I understand it, where there are arguably dual motives for a particular allegedly improper conduct, the city could still prevail if it showed that it would have done the same thing anyway.
So, Your Honor,
the only thing that changes is that it has the burden of proof that it would have done it anyway. Do you agree with that?
That's almost correct, but under a motivating factor, to establish liability under Title VII, all Chief Hittle has to do is prove that his religion was a motivating factor in his termination. And under a motivating factor theory, the city would then have an affirmative defense that it would have terminated Chief Hittle anyway. And that affirmative defense goes only to remedies. So that would prevent Chief Hittle from recovering damages for his termination. But for liability on motivating factor, that is irrelevant. And Chief Hittle would still be able to get injunctive, declaratory relief, and attorney's fees. Great. Thank you.
Okay, thank you, Ms. Butler. I think that covers our case. I'm going to thank Ms. Butler and Mr. Wilson for their excellent advocacy. This case was well presented on both sides. We will now submit this case and go on to our last case for the day.
Your Honor.
Thank you.
Mm-hmm.